This is The Issue, and I am the Ghetto Man. Today's issue, the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Don't go away. We'll be right back. A group of government agents just kicked your door down, entered your home, and began tearing your home apart, completely destroying everything in their path, looking for something. "What are you looking for?" you ask. "Shut up," responds one of the agents. "We'll let you know when we find it." Now, this is the scenario that our nation's founding fathers experienced while under the rule of England. And this is also the scenario that so many people experience in so many totalitarian, communist, socialist, fascist, democratic countries worldwide today. Now, I think that George Washington said it best. He said that government is not reason, it's not eloquence, it's force, a dangerous servant, and a fearful master. So today's issue, a brief introduction to the Fourth Amendment to the United States Constitution. The inalienable right to be secure in your persons, houses, papers, and effects against unreasonable searches and seizures. The Fourth Amendment is all about privacy and property. The inalienable right to live one's life free of government interference whatsoever. The right to be left alone, especially in our homes. Now, the Fourth Amendment is also part of what we refer to as due process of law. So what is due process of law? Well, due process of law is a fundamental, inalienable right protected constitutionally by the Bill of Rights that guarantees that all legal proceedings will be just. And when I say just, I'm referring to justice. And that the accused, no matter who they are, rich or poor, will be given the opportunity to publicly present or defend their case pursuant to a fixed standard of law as mandated in the Bill of Rights. An opportunity to plead one's case before a jury of one's peers and then to be found guilty by a jury of your peers before the government can take anyone's life, liberty, or property away from them. The Fourth Amendment has two parts. It's one sentence, but it deals with two entirely different subject matters. One addressing the inalienable rights of the sovereign citizen, and the other addressing the procedure the government must follow in order to search or seize a United States citizen and their property. Now, Part 1, addressing the inalienable rights of the sovereign citizen, states to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now, this part of the law, this what I call the first half, is, if you look at the wording, it's all-encompassing. It covers and includes all aspects of the inalienable right to privacy and property. Very important. Now, what is property anyway? Well, I'm going to go to Bovier's Law Dictionary. It was a dictionary that was sanctioned by Congress as the official terms and definitions of the Declaration of Independence and the U.S. Constitution. And it states the very definition of property, and please pay attention to this because it's very important in order to get to understand what property really is. Property: the right and interest which a man has in lands and chattels to the exclusion of others. It goes on to say, the sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe. I think that encompasses everything, the entire universe, which I believe, and I believe our founders meant, government. This includes government. Today, the definition of property would include the digital extension of ourselves. We're all involved in the computers and hard drives and storing documents and stuff digitally. And, when you take a look at it, the digital world is nothing more than an extension of one's physical and intellectual property. I mean, to claim otherwise would run contrary to the right of personal freedom and the right of freedom of thought. You should be able to take your thoughts and put them onto any paper, in some kind of electronic storage, and it's all the same thing. I know that people would sit there and say, well, the electronic is different. It's not different. Whenever you're dealing with somebody's property, you're dealing with everything that extends from their person, everything they own intellectually, everything. Okay, now the second part deals with the procedure the government has to follow in order to search or seize a sovereign citizen's person or property. And it states, this is all one big long sentence, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, let's break that down. And no warrant shall issue. So in order to search and seize a citizen, the government must have a warrant. Well, what's a warrant? Well, for the purpose of this video, we're going to talk about two kinds. One in the arrest of the person and one of the arrest of the search and the seizure of the property. And most of the time it encompasses both. But going to Black's Law Dictionary, 2nd edition, the definition of a warrant of arrest is a written order issued and signed by a magistrate directed to a peace officer or some other person specifically named and commanding him or her to arrest the body of a person named in it who is accused of an offense. Now, a search warrant, it would have this in its contents. A search warrant would be another order, and it'd be in writing, issued by a justice or a magistrate, in the name of the state, directed to the sheriff, constable, or other officer commanding him or her to search a specified house, shop, or other premise for personal property alleged to have been stolen, or for unlawful goods, or to bring the same when found before the magistrate, and usually also the body of the person occupying the premises, to be dealt with according to law. Okay, following no warrant shall issue, there's a phrase, but upon probable cause. Well, what is probable cause? Well, the definition of probable cause is sufficient reason based upon known facts to believe a crime has been committed or that certain property is connected with the crime. Probable cause requires reliability. A provable fact that directly ties the accused and his or her property directly to the crime. And probable cause has to be, as far as a warrant's concerned, supported by oath or affirmation. See, when accusing any person of a crime, the accuser must do so under penalty of perjury. And this is usually done by oath or affirmation. Well, an oath, we've all heard that term. We all know, seen people swear oaths. There's nothing more than a solemn promise, often invoking a divine witness regarding one's future action or behavior. And an affirmation, well, that's just nothing more than placing oneself under the penalty of perjury. Either way, you got to tell the truth. You see, a false statement on an affidavit is a criminal offense. Now, the warrant must also describe the place to be searched and the persons or things to be seized. Now, to give you an example, on the warrant, the person who signs the affidavit says that identifies that the stolen money can be found at 555 Constitutional Drive, an example, wherein I saw the accused steal the money from a lady in the drugstore parking lot on such and such a street. And then I later saw the accused put the stolen money into a wooden box and place it on the top shelf of a roll-top desk in his den. Okay? And then I signed that under the penalty of perjury. And once all of this is in place, the police take the warrant, and they go to 555 Constitutional Drive, present the warrant, arrest so-and-so, search the house, find the desk, find the wooden box with the stolen money in it. They seize it and off to jail with the perp. And the evidence is secured. The only way constitutionally that the warrant requirement can be set aside, and it's not really being set aside, is when a crime is committed in the presence of the person making the arrest. You see the person take the item, shove it in the pocket, and run off. That's probable cause. You have probable cause to make an arrest, and that arrest can be made by a peace officer or by a citizen. I'm sure you've heard the term citizen's arrest. In a free society, everything that belongs to you, everything that you own, everything that is meant to be private, including your thoughts, are off limits to government, shall not be violated, unless the government follows the guidelines and protections as outlined in the Fourth Amendment. Remember, the Fourth Amendment did not create the right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures. These rights exist whether there is a Bill of Rights or not. They exist whether there is a Constitution or not. They are God-given, or if you don't believe in God, natural rights. God-given or natural rights, they are what we refer to as inalienable rights. You see, all that the Fourth Amendment did was secure those rights. In other words, the Fourth Amendment is a secondary restriction. The rights itself, being the first restriction, are placed upon government as a prohibition from them forever tampering with these rights. No one, especially a servant government, can arbitrarily take anything that belongs to you without due process of law. Now, if the government does otherwise, then the government becomes a lawbreaker, right? Now, never, under any circumstances, consent to a warrantless search. Never. Always demand probable cause and a Fourth Amendment warrant. And also demand to have counsel present and well. And after that, don't say anything further. 3 basic rules to remember when dealing with government. 1, don't say anything. 2, keep your mouth closed. And 3, shut up! Remember the Miranda warning? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided for you. Remember that. You have a right to remain silent. Don't ever forget that. Never, ever forget that. A person cannot be convicted of something that he or she did not say. Now, I realize I'm a little off subject here. The right to remain silent and the right to counsel. We're going to cover these things in the next 2 Red Pill series videos. The right to witness against yourself, the Fifth Amendment, and then your right to counsel and counsel of choice, the Sixth Amendment, all part of the Bill of Rights. And as you'll soon see, all of this, the Bill of Rights, it all fits together. Okay, getting back to the search and seizure. The moment that you give your consent to a warrantless search, you lose your Fourth Amendment protections. You must demand the right, and you must demand that right in person. Now, I'm going to quote from a case that I've used before. It's called United States versus Johnson. It's a federal supplement case. It can be found in book 76 on page 538. And we're going to read the ruling of the district court judge. His name was James Agler Fee, and he said this in his ruling. He said, "The privilege against self-incrimination is neither accorded to the passive resistance nor to the person who is ignorant of his rights, nor to one who is indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be acclaimed by an attorney or a solicitor. It is valid only when insisted upon by a belligerent claimant in person." You see, a consensual search is nothing more than witnessing against oneself. You're allowing the government to just arbitrarily, you allow them to go in and start looking wherever they want. And if they do find something that's illegal, without a warrant, they can charge you with that. See, with the warrant, they're very limited as what they're there for and what they're looking for. Now, failure to demand a constitutionally protected right presumes that the right has been waived. Make it clear when you're dealing with the officers. Make it clear. Officer, without probable cause or a Fourth Amendment warrant, you do not have my consent to search me or any of my property. And as I said earlier, also demand that you have counsel present and do not say another word. You see, if you don't do this, anything that is found on your person or property can and will be used against you in a court of law. Even if that contraband that the police pended on your body, in your car, and in your house, it can and will be used against you. Remember that. Remember that. Now, on the other hand, if you refuse to give your consent and demand probable cause and a Fourth Amendment warrant instead, any evidence that's found can be moved to be suppressed. It cannot be used against you. The evidence is what? It's tainted. It's no longer trustworthy. It's the fruit of the poisonous tree. You see, government has to prove that the evidence wasn't obtained illegally and wasn't part of a government plot to frame the accused. Without a lawful warrant, there is no way that the government can prove that the evidence wasn't obtained illegally. Now, there are exceptions to the rule, and they will be addressed in another video. Right now, it's important for you to understand the basics. Remember, you are innocent until the government proves that you're guilty. It's the government's job to prove your guilt, not you. The Fourth Amendment, what it does is it keeps everything and everybody above board and protects the citizen from an overzealous or corrupt government. Today, the Fourth Amendment is all but ignored by many of the government bureaucracies like the Department of Family Services, who take children without a warrant or probable cause. They deny people hearings. They place their children in foster homes, and the parents don't know where they are. You have the IRS, who seize bank accounts and personal property and real estate and everything else, and they do it without due process of law. You have civil forfeitures where police will seize cash that they find in a person's automobile, and then they basically say they're charging the cash with a crime, and in order for you to get it back, you have to prove that the cash wasn't involved in the crime, even though they have no crime to tie the cash to. And this goes for any other government agency that seizes property or imposes fines and penalties without affording the citizen the constitutionally protected right to due process of law as mandated by the Bill of Rights and the 14th Amendment. And we'll cover the 14th Amendment in another video. Now, although the courts in the past have upheld the restrictions and requirements of the Fourth Amendment, the courts in more recent times have played a major role in watering down those restrictions, giving the executive branch of government greater freedom to openly violate the protections guaranteed by the Fourth Amendment. Now, there are a number of United States Supreme Court cases that cover the history, the intent of the framers, and the application of the Fourth Amendment. But because of time, I'm not going to cover these cases in this video. We'll have to do that at another time, and we'll do that in a more comprehensive video discussing those specific cases. In the meantime, I have listed some of the more important United States Supreme Court cases on the subject, complete with citations, and as you can see, they're on the screen to my left. I encourage you to look them up and review them. I'm the Ghetto Man. Thank you for watching. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. And remember, in a free society, playing it safe is the most dangerous thing that you can do. Please subscribe to my channel, and please share.